Okay, this is week 7. It's Monday, and it's the 180-200 speed and accuracy class. This is a legal straight matter, for the record. Ladies and gentlemen of the jury, in this case, this is not a duck hunting accident, all right? This is not a duck hunting case. This is not involuntary manslaughter, all right? Now, next we move up our scale to what is called voluntary manslaughter. It's called heat of passion, a cooling off period. And the classical example is when a husband comes home or a wife comes home, you know, and they see their spouse in bed with someone else. And this person is a law-abiding citizen. The person had no knowledge that this act was taking place. And all of a sudden, the passion and the rage builds inside, and they're just so infuriated and they're so upset that they go into a closet where they know a shotgun is, and it's a loaded shotgun, and they fire it at the bed. You know, right there, they haven't had a chance to walk around the block or to drive someplace to think about it to cool off. That's what we call voluntary manslaughter. It's done in the heat of passion with no cooling off period. We do not have a husband cheating on his wife here. We do not have a killing that was a result of heat of passion without a cooling off period. We have something completely different. Okay, on our spectrum, then we go up to what is called second-degree murder. Second-degree murder is an act that is done with a high probability that it's going to result in death with a conscious disregard for human life. It really doesn't require an intent to kill for second-degree murder. Once again, I like to use examples. The best example of a second-degree murder is what we call in this business baby killing cases, where you have a little child that's screaming and you have a parent that is trying to get the child to be quiet, and they're so frustrated that they hit the kid to try to get the kid to shut up. And they hit the kid too hard and the kid dies. Well, that's an act done in conscious disregard for human life. That would be second-degree murder. Another example of second-degree murder is where you have a person that is sitting on a rock and they see a crowd of people down below. They just take their weapon and they just fire it into the crowd. They could even put a blindfold on so that they could say, I didn't know where I was shooting. But you see, when you fire into a crowd, even though you don't intend to kill someone, there is a high degree of probability, or a high degree of probability exists that death is going to result from that act. Once again, another example. You have a person sitting on a rock and they have a high-powered, rifle, and they see the Amtrak train coming down. Let's say they're only about 100 to 125 feet away, and it's, marked Amtrak, so we all know the passengers are inside. From where the person is sitting, they can't see the window, so they don't know if passengers are there or not. But, maybe a quarter of a mile down the road, they see the people who are lined up to get on the train. And right before the train was passing by, the train stopped. They saw passengers getting on the train and off the train. And they just fire, and one of the shots goes right through the train window and kills a passenger. Well, obviously, that's an act done with a high degree of probability that it's going to result in death. There is a conscious disregard for human life. That's what we call second-degree murder. Once again, we're moving on our spectrum. We're going from justifiable homicide, the duck hunting accident, involuntary manslaughter. The husband coming home and seeing the wife in bed with someone else, voluntary manslaughter. The person sitting on the rock and firing into that moving train with passengers aboard as second-degree murder. And then that leaves us with what is called first-degree murder. The only difference between first-degree and second-degree murder is that the killing was the result of what we call premeditation and deliberation. Let me speak a little bit about premeditation and deliberation. You don't have to graduate from law school to understand guilty of first-degree murder. I hope you are with me so far, as you can ask questions later as the situation develops. Before the English language was ever developed, or before any language was developed, I'm sure they had cave people and maybe even had a case where, somebody goes out for a big hunt and they kill a bear or a lion. They have that catch in their cave. and then they go out and kill something else. They come back and there's the fire going, and the bear's meat is all gone, and the cave buddy, is sleeping, and he's grunting and he's snoring and he's burping because he just got through eating that guy's meat. And this guy doesn't like that, and he grumbles a little bit and takes a club and goes over and bashes his head in. What I'm getting at is that first-degree murder has been around a long time. It doesn't take a brilliant person to plan and to deliberate the killing of another human being. It is something that can be very crude. It can be something that's very sophisticated. It can be something that's very stupid. And in this case, you look at all the mistakes that the defendant made in covering up his tracks, and you think, where in the world was this guy at? Was he out to lunch? What was he thinking? What was going through his head? But once again here, ladies and gentlemen of the jury, that doesn't mean to us that he's not guilty of first-degree murder. As I indicated, you don't have to have a college degree to be guilty of that. The other thing about first-degree murder I want to talk to you about is this. The law doesn't say how much time has to elapse while this person is thinking and planning. I mean, it can be 5 seconds, it can be 5 minutes, it can be 5 hours, it can be 5 years. You as the jury are going to decide what you feel in this case is the requirement for premeditation and deliberation. So that's the law of homicide. I ended with first-degree murder because when we get into how to prove first-degree murder, and also when we get into how to prove that the defendant is the one who killed Mary Slater, we talk about this concept called circumstantial evidence. And let's look at our elements that we have here for first-degree murder. Okay, let's see. Let's do... Okay, jury charge. Ready? For the record. Members of the jury, preliminary to your being accepted and sworn to act as jurors in this case, you were examined both by the state and the defendant as to your competency and qualifications to act as jurors. And as a part of such an examination, each of you answered all the questions asked you both by the state and the defendant, and your answers show you were competent and qualified to act as jurors, and the parties to this case on trial accepted you as jurors on the faith of your answers. The answers you then made to said questions in regard to your competency, qualifications, fairness, and freedom from passion, sympathy, and prejudice are as binding on you now as they were then, and should so remain until you are finally discharged from further consideration of the case. You are instructed that during this trial it became necessary for the court to pass upon objections made by the attorneys and to make remarks from time to time. You are instructed that by any ruling or remark which the court has made, the court did not intend, nor does the court now intend by the instructions to indicate that the court has any opinion on the facts of the case. The determination of the facts in this case is solely and wholly within the province of the jury and the jury alone, as you apply the law given to the jury in these instructions. The court further instructs the jury that these instructions are given and should be considered together as one entire series, and each instruction should be considered in connection with all instructions bearing upon the same subject. If, in putting in the evidence or in argument, counsel for either party has made any statement not based upon the evidence, or if counsel made any statement which he afterwards withdrew or which the court afterwards struck out, the jury should wholly disregard such statements. The court instructs the jury that the court is the sole judge of the law in the case, and it becomes the duty of the jury to follow the law as it is given to it by the court in his instructions. You have no right to disregard them or disregard any portion of them, but you are bound to take the whole of them as they are given to you by the court and apply them to this case. The indictment in this case is not to be considered as any evidence of presumption of guilt against the defendant. It is a mere formal charge necessary to place the defendant upon trial. The defendant under the law is presumed to be innocent of the charge in the indictment, and this presumption remains throughout the trial with the defendant until you have been satisfied by the evidence in the case beyond all reasonable doubt of the guilt of the defendant. This presumption of innocence is not intended to aid anyone who is in fact guilty of a crime to escape, but is a humane provision of the law intended, as far as human agencies can, to prevent an innocent person from being convicted. Throughout this case, the burden of proving the guilt of the defendant beyond all reasonable doubt is on the state. The law does not require the defendant to prove that he is innocent. If, therefore, you are convinced from all the evidence in the case beyond all reasonable doubt that the defendant is guilty as charged in the indictment, it is your duty to find such defendant guilty. If, on the other hand, you are convinced from the evidence beyond all reasonable doubt of the guilt of the defendant, it is your duty to find such defendant not guilty. The court instructs the jury in the language of the statute that murder is the unlawful killing of a human being with malice aforethought, either express or implied. The unlawful killing may be perpetrated by shooting or by any other of the various forms or means by which human nature may be overcome and death thereby occasioned. Okay, that got up to 220. Okay, I'm going to slow it down a little bit. We're going to do some more on malice aforethought, because that term is in the tape today.
What is it? M-A-F-R-T?
M-A-F-R-T? Mm-hmm. Is there a, what translates to just A-F-R-T? Like if you wanted to say aforethought. I don't know a brief for just aforethought. Does anybody? Nothing? I mean, if you're going to do malice aforethought, M-A-F-R-T, if you just do A-F-R-T, couldn't you do that as aforethought? If nothing's coming up. Okay. Ready? Yeah, okay. For the record, ladies and gentlemen of the jury, we have charged the defendants collectively. You must decide this case as individuals. You are not bound to find one guilty, two guilty, or vice versa. In reality, there are two cases going on here at the same time. The judge will issue further instructions on that later. When I am arguing both cases at the same time because it is easier and it goes faster that way. Murder is a killing with malice aforethought. The judge is going to instruct you on this. He will tell you that malice can be either express or implied. Express malice is when a person expressly says he intends to kill somebody. Here, malice in this case is to be proven circumstantially. I told you at the beginning of the trial of this case that the case is based entirely on circumstantial evidence. Nobody saw the killing. The crime that is charged, the degree of the crime, and what was in the mind of the perpetrator at the time the crime was committed is all proved circumstantially. The judge will instruct you that that is as good as any other type of evidence. It is as good as direct evidence. Now, implied malice can be shown several ways. One way is when the killing is the direct result of the attempt to perpetrate a felony called the felony murder rule. We have already talked about that. I will not go into that any further at this time. The felony murder rule doesn't require any ill will or hatred toward the victim. The rule requires that the killing take place during the course of the perpetration of a felony. We have defined malice for you. Now, let's define aforethought. Aforethought means deliberation. It requires that the person deliberates and premeditates the murder. It requires that the person thinks about the murder prior to the killing, not after. You don't decide to kill a person after he is killed and have first-degree murder. There are 3 theories of murder that can be going on in this case. All 3 of them are equally applicable. We are not splitting the offense or anything like that. We are going right down the line, and you, the jury, can find each one of them present in this case. In the felony murder rule, the killing took place during the course of a robbery and/or burglary. In first-degree murder, the basic premise is that the killing was willful, deliberate, and premeditated, because all willful, deliberate, and premeditated murders are murders in the first degree. Now, what does deliberate mean? Deliberate means being determined as a result of careful thought and careful weighing of the consequences. Deliberate also means not rash or hasty. Deliberate means to think or consider carefully. What does premeditated mean? Premeditated means to be considered beforehand. Premeditated also means to think out, plan, or scheme. As the jury instruction says, formed upon pre-existing reflection and not under the heat of passion. If somebody attacks you and you turn around and kill them, that is a heat of passion killing. That is not first-degree murder. All right, take a look at that.